The next case on the calendar today is Leticia Pupo-Conde versus Intraknits Incorporated and Bridegfield Employers.
Good morning. May it please the Court. Jay Levy and Angel Garcia on behalf of the appellant respectfully request 2 minutes for rebuttal, if I may. This is an appeal from an interesting order from the Judge of Compensation Claims, and I don't say that lightly, but a review of the order leads one to have many questions as to exactly what the ruling is. The specific issue that's being appealed today is a gap period created by the judge's ruling in which no benefits are to be payable. To briefly summarize, this was a claim that went on permanent total disability, and as your honors know, in order to prove PT, when maximum medical improvement has been reached, but when the client is not actually MMI, meaning that there's still a period of time remaining for improvement to be anticipated, you have to put on testimony that anticipates that when the claimant reaches MMI, they will meet that threshold. In this case, the judge found that the 6% permanent impairment led little support to a finding of PT, found that the examining but not treating psychiatrist anticipated that there would be improvement, and therefore that did not support PT, and didn't consider the vocational testimony, finding that she did not believe the claimant, and therefore the vocational testimony dependent on the claimant's testimony would not be credible. I would point out parenthetically, she did accept the psychiatrist's testimony, also dependent on the claimant's testimony, that there was a major psychological or psychiatric disorder at the time, and that she was in 100% disabled, totally disabled at that time. I would also point out that he did accept the testimony of Dr. Suarez that there were problems with the claimant, and that the claimant needed a thoracic MRI. I point that out only because it gives further question to this finding as to what the claimant's status was. She found that the claimant reached MMI, but yet sent her out for further diagnostic testing based upon Dr. Suarez, who based his opinion on what the claimant told him with their subjective complaints of pain. So I'm left to ponder for the court the following. On the one hand, the claimant's not believable according to the judge. On the other hand, the claimant is believable because she relied on all these other doctors. But the real issue in this appeal concerns temporary total and permanent disability. There is no question that the 104 weeks expired in this case. There is no question by statute we lost our 104 weeks. There is no question that the judge denied the permanent total, finding that the claimant be premature. And there's also no question in this case that the problem with the claimant's condition and why she couldn't prove her case and why this case couldn't be finally adjudicated rests not at the claimant's fault, but at the fault of the employer carrier. And I point that out because in their brief, they take issue with the claimant. They say this is all our fault. We control these benefits. We could have proven this. We could have filed this. But none of that is true here. This case has a fairly shocking procedural history. The psychiatrist who determined that the claimant was totally disabled rendered a report on January 26, 2003, saying the following. In essence, she needs to have psychiatric treatment. The judge accepted that. The judge ordered psychiatric treatment. We have no determination of what that psychiatric treatment is. We have no finding of disability. We have no determination of what her impairment will be. We have no determination of whether there will be an interactive impairment between the psychiatric and the anatomical. We don't know any of that. All we know is that she's totally disabled. The judge, and we take that and we go to this hearing and we get an order 3.5 years later on August the 16th of 2006. We have a trial that doesn't take place until December 5th, 2005. So there is, in effect, a 3.5-year gap with no benefits paid because the 104 weeks has expired and because the judge finds that there is no entitlement to PT at that time because the claim is premature. Yet she remains totally disabled, as per the psychiatrist and as per the judge. And even if you didn't want to consider the anatomical condition, if you consider the anatomical condition, then your honors have to ask the following question: why would she have adjudicated and found that the claimant had reached MMI when she sent him out for thoracic spine examination. The long and the short of it is, this court has been, and I apologize for the use of this word, but this court has been creative in the past. The legislature, respectfully, cannot accomplish and cannot accommodate all situations that it considers when it passes a statute. I have relied upon the Emanuel case, and I know that the Emanuel case is a little different. I know that there he reached MMI, although in reading Emanuel carefully, it is puzzling to me that the court can at one instance say that Mr. Emanuel had a 14% anatomical disability and at the same time say that he was totally disabled at the same time without any explanation as to why. It does seem a bit inconsistent. But we say, similar to what this court did in the Emanuel decision, this court should do here. We had a totally disabled claimant here. There's no question. Judge found her totally disabled, found that she hadn't reached MMI. We found that the reason that she hadn't been able to finalize this case is because although Dr. Brown in his report of January 24th, 2002, which the judge relied on and accepted, found that she was very depressed and needed care. We found that, and he was an authorized doctor. We have Dr. Suarez, also an authorized doctor, on February 7th, 2003, stating that she needs psychiatric intervention. They ignored all of this. In the pretrial stipulation, they contested the psychiatric condition. So we're in a situation here where we have no treatment, we have no treating doctor, we have no opinion on impairment, we have none of that, not our fault, they resisted. This case took 3.5 years to get to a final adjudication, and the final adjudication is go get your treatment. But what about the indemnity benefits? What about the gap?
Well, counsel, what troubles me is the tests laid out in Olmo.
Okay.
It seems to me that the difficult part of that test and the issue here is establishing that the claimant will be permanently and totally disabled at the future MMI date.
But the assumption in Olmo is that you are available to have the proof to make that, to prove that up. Here, we do not get that proof because at the same time as the judge is adjudicating this issue, she's adjudicating the psychiatric issue. All we know, Judge Van Norwick, is that there was a one-time IME which said 4 years before, 3.5 years before the order comes out, she's seriously depressed, she's got a major psychiatric condition, and she's got an adjustment disorder. And I think you should get the treatment. Until the treating doctor sees her, until the treating doctor has an opportunity to treat her and render her his opinions, we're deprived of that information. We can't prove the case psychiatrically because, as your honors know, only authorized IMEs, et cetera, can testify. The IME testifies, yeah, I saw her and, you know, I was asked to determine that she needs treatment, and yes, she's got a major condition. So
the rule you're asking us to craft, I'm trying to understand, is where the claimant, it is impossible for claimant to establish the second element of the Olmo test because the claimant has not been able to go to a treating physician. Then we're going to come up with a new test and say PTD benefits are payable all along? That's what I'm struggling with.
I don't think I'm necessarily asking this court to tread that far where it hasn't been before. I think this court started down the path in Emanuel when it said that although the claimant had reached MMI, she was totally disabled and we can still go back even though she was released for work and find PT going back for those 3-year period. In this case, based upon the state of the record, I don't think that the legislature had ever intended that there be a gap in benefits, a gap when it's not the claimant's fault. And this case is a little unique. I have to be candid with Your Honor. I don't know that this situation will come up all that much, but it does exist here. And it needs to be addressed here. This lady has gone for 3 years without her benefits. All we know is that she was totally disabled. All we know is that the 104 weeks ran. And all we know is that she couldn't prove the essence of her case because the carrier didn't give her the psychiatric care which the judge has now ordered. Respectfully, we think this order should be reversed. We think this order is inherently contradictory in its credibility findings, and I do want to save my last 30 seconds. Thank you.
court. I'm George Kagan, speaking on behalf of the Appellees Intraknits, Inc. and Claim Center, or Summit Consulting. I'd like to be notified when I have 2 minutes remaining. The axiom bad cases make bad laws applicable here, but given the protracted proceedings, one of our more difficult subsections of the Act to parse through, claimant's laundry list of disconcerting testimony and even complaints, and each party has contributed its fair share of being off the mark now and then, my goal is to simplify the case in 4 steps. Number 1, I will start with waiver. There was a failure to preserve this black hole argument. Whereas the JCC is not empowered to strike a measure as unconstitutional, the JCC is certainly empowered to interpret the statute. This was not asked of the JCC below. As a matter of fact, this whole claim was tried on the basis that she was fully PTD and MMI, and she's failed in that regard. She's disappointed in that regard. She's actually mistaken when she says in page 2 and 3 of her brief that the claimant has achieved statutory MMI 2 years after the accident. As we all know, the 2-year period is a cumulative period based on benefits paid. That's why the claim is technically premature by 6 or 12 weeks. So, first is the waiver or failure to preserve argument. Now, the de novo standard she has urged constrains us to disregard her whole grievance, which takes 8 pages of her statement of facts, on the denied premature PTD claim. It was effectively 6 weeks early. The law allows us to make the determination at the 98th week, and she was at the 92nd week of accumulative benefits. Now, the facts are what they are. The JCC did not buy her PTD claim even if 6 more weeks had been paid, rendering that component of her claim either premature or denied. Now, the part 3 is my part. I do not feel we can justify our alternative argument presented in the brief, which is perhaps where I maybe overshot the field a little bit, where I said the judge has definitively ruled that her claim is denied, her PTD claim. On further reflection of the whole case and the circumstances and the various contentions of the parties, especially as guided by a case of this court decided a few weeks ago, I now feel that she can, on the attainment of the actual statutory MMI, try her PTD claim, but probably requiring some sort of different condition than she had presented at the trial level. I wouldn't think that she could present the identical witnesses again. What helps me get there is this court's opinion a few weeks back in Myers versus Hillsborough County, case number 1D07-0229, decided 4/23/08. And in that case, which I have here, and I gave a copy to counsel this morning, claimant filed a premature petition. Well, claimant went for it. She went for it in 2000, was denied. In 2006, she brings a PTD claim again. And they said she was stopped to do that. And the court ruled, no, it wasn't ripe then, so it's not barred by res judicata. It will be ripe one day in the future, so come back again another day. I think an element of change in condition must be shown for her having tried the entire PTD case. You know, she didn't accept or acknowledge that it was premature. It just got found that way. So here she is scrambling with a new and improved argument. In this respect, I would also point out that part of the confusion is the judicial nomenclature. At the judge's order, page 21, in the record at 762, she says, accordingly, claimant's request for PTD is premature and must be denied because she has not reached overall MMI. A better word there would have been statutory MMI. And even if she had reached statutory MMI, again, I think that's a misstatement, there is no CSE that establishes she will be permanently totally disabled after overall MMI. Again, the better word there would have been statutory MMI. However, the judge cites all the correct authority. The judge cites the Palm Beach dermatology and the Olmo case, and that sets the scene where the expiration of the statutory period, which is the cumulative weeks, not the calendar weeks, has not yet occurred, then the claim is premature. However, if it were premature, to answer one of claimant's questions about impossibility, she's entitled to ask doctors to speculate about her future condition. But that became effectively a moot inquiry because statutory maturity had not yet occurred. So, as I said, I withdraw my little bit of ambitious argument in the alternative, which is to say, let us say that her claim is permanently denied. I can't quite get that out of this. But now let me go to my fourth point, and that is as to her main event, she asked the court to read absent terms into the law, to the effect a patch that will entail potentially unlimited additional benefits. Now, we have a 104-week cap. There's always been a cap in the law on TTD. This is perhaps the strictest one that's ever been there, but it's there. Now, in her fairness to one claimant request, and this law has been around for 14 years, we've never had this request, she wants a whenever cap, which is virtually unlimited, if you follow her reasoning to its natural conclusion. Has she thought about it? Not likely. And that means, that points the way here that this goes beyond, this is entirely a question for the legislature. It is they to whom claimant must address a grievance of this sort. And her leading case, as she touts, the Emanuel versus David Piercy, is not even applicable in the least, because it's not a premature case. It's not an accumulative premature weeks case. So, yes, there have been cases that allow a renewed period of TDD. That is completely irrelevant to the legal posture of this case. It is not leading, it is not even persuasive, whereas Myers is persuasive. So, and incidentally, in terms of the fairness argument, the only thing I could argue equitably in terms of, we didn't authorize a thoracic MRI, but we authorized nearly 12 doctors, cervical MRIs, shoulder MRIs repeatedly. We began to get questioned the bona fides of this case, and the judge gave a laundry list of why she didn't believe the claimant in many crucial respects. It should be remembered we had an IME to support our position. Dr. Castillo felt this was a contrivance based on getting a claim going. I won't say any more about that because this is not a facts case. We have a de novo standard. So in short, the JCC dealt with an odd lot of a claim, what we might call a statistical outlier. And she did an okay job. We ourselves were surprised at the benefits found due, which I could argue had we cross-appealed, but we waived our right to cross-appeal, so we have accepted our defeat, so to speak, in the manner in which the order was entered. However, the JCC did not err in failing to award benefits that are not provided for by law, and this court cannot install them. And I would remind the court of the axiom, bad cases do make bad law. This one would certainly qualify. And one comment about the equity. I'd like to go back to one of my first significant cases that I was involved in the mid-'70s, my first, actually, and that was Ferguson versus Mims and Thomas. I thought of it just sitting here, and that's a case where the Supreme Court's, it was an attack on the unfair schedule of impairment benefits. And the argument was, how can we pay a violinist for loss of a middle finger the same that we pay a jackhammer operator? And the Supreme Court says it might be entirely unfair to treat a pianist the same as a construction worker. But that's the nature of the workers' compensation law. It does not look by its very nature to do justice in each individual claim, but in the broad sweep of claims generally, which implies that there will always be the inequitable result. But that's not the damnation of the act. That's the nature of the act. Equity for many, inequity for a few. All of our schedules and limits and restrictions. That's the nature of the act. So it lands hard on her. Part of the reason this case is so protracted, it's hard to understand myself, but the point is, bad cases make bad law. 14 years we haven't heard this argument. It's not worth upending the law for. Affirming, perhaps with a cite to Myers, is all that is indicated here. Thank you, Your Honors.
I'm left to state that we could have a philosophical decision as to whether the workers' compensation law benefits all, but that's for another day. 3 points, and I will be finished here. First, I think Mr. Kagan makes my point. He points to Myers and says that it's premature, you can always go back and do it again, but that still leaves a period of time for which there are no benefits to be paid. And as I say, you have to have the right doctors to prove your case. On the one hand, they're saying you shouldn't get your benefits because you didn't prove your case, and this is the way the statute is. On the other hand, they resist the opportunity where we are to go get it, to go get the doctors we need by saying that the psychiatric is not related. And I would point out, interestingly enough, in closing, points out that they had a psychiatrist, Dr. Castillo. But the judge rejected Dr. Castillo in favor of Dr. Sandoval, who relied on the claimant who testified, but the claimant's not, but although he relied on the claimant, and obviously, but the judge found the claimant not credible. Nothing makes sense in this case. We respectfully request you need to reverse and remand and find that she's entitled to disability for that time period. Thank you.
Thank you, counsel.